Good morning.
Morning.
Surprised you're up.
Yeah, yeah, I don't really know how many of these cases paperwork was already sent out to the defense
Just-
attorney. So
Yeah. Not many, I don't think. I haven't, the only ones that I have are the ones that you sent. So, and because Jose sent the same ones.
well, he may have sent copies that didn't have my signature yet. I'm not sure. But
That's
anyway,
right.
sorry about the duplicates if that happened.
You are perfectly fine. All right, I'm going to do some side work while we wait on everybody else to get going.
That's what I'm doing.
Yep.
Good morning, Elizabeth.
Morning.
Morning.
I hit the allow to record for you.
Okay, thank you.
Yes, ma'am.
Hey.
Morning, Izzy.
How you doing, Liz? You
I'm
hear
good,
me?
honey. How are you?
Good.
Are we ready over there at the jail already?
Let me see. We got the first 5 down. Let me see. Hey, do we got
Okay.
the first 5 down? We got 2 5. Yeah, from 2 7. We got. He's going to
What
get
is
5.
going on with my hair today?
Right here. Yes, the first 5 down.
First 5 are down. Okay, I'm gonna give it 3 to 4 more minutes. Exactly at 9, I'll let Judge know.
I appreciate you.
Thanks, guys. Good morning, Miss Gardner. I don't think you're connected to audio. There you go. Now you're connecting.
Oh, I.
Hey, excuse me, do anybody hear me?
Yes, ma'am.
Oh, I was just trying to figure out if I had it on there right.
You do. Yes, ma'am.
Okay, all right. Do I need to mute my phone again?
Yeah, keep it muted until we call your case. It just
Okay,
helps with the background noise.
yes, ma'am.
Thank you.
Miss Barker, you just get prettier every day.
Oh, thank you, honey. I don't see your face, and your face is beautiful too.
Can you hear me?
Yes, we can hear you, Mr. Denson. Thank you.
Okay, just mute my phone.
Yeah, just keep your phone muted for the time being.
So how will I know when it's my turn?
They'll call your name. You should be able to hear it.
Hi, good morning.
Good morning.
I don't know if I'm in the right place or not. Is this, I guess, telecourt or Zoom court?
Yes.
All right. How does this process work this morning? I know since we have COVID, things are a lot different now. So I have I'm the defendant. No, my defendant or plaintiff. I guess I'm the plaintiff in this case. And I was told to log in for this case this morning. So what do I do?
Yes, sir. You'll just wait and listen for your name to be called and then proceed after that.
Okay.
Okay. Thank you.
So I just hit the mute button, or you're gonna be able to mute me?
I can mute you.
All right.
When you hear your name
you-
called, you have to unmute yourself though.
I found the mute button, Liz. I got
Okay.
it. Thanks.
Yes,
All right.
sir. All right.
Sir, if you're a plaintiff, I'm not sure if you're in the right place. These are criminal court hearings.
Yes, so criminal court hearing, there's a bond hearing, I guess, scheduled for this morning.
Okay.
Hey, is everybody tracking that we're supposed to be off of Zoom on the jail side at 12 noon due to tag reader court and also Judge Peters court in the AV room?
I'm sorry.
If you're asking the court if we are aware of that, yes, we are. We will not be coming back this afternoon for afternoon session.
Okay, I just want to make sure everybody's on the same page with that.
Yes, sir. Thank you.
Hi, good morning, everyone. We'll call through the docket for announcements. Number one is State of Georgia versus Brandon Barfield. Mr. Guzman.
Your Honor, on Mr. Barfield, he's on for bond hearings, and he's also on for, I see that he's also on for this plea. The plea will not be occurring today, but we will have a bond hearing on the 3 cases that are on the dock, including this case.
All right. He's in the third group, Mr. Guzman, as you might know. Number 2, State of Georgia versus Ray Cokes. Mr. Gardner.
Not sure if Mr. Garner is here, Your Honor. I know that we have extended an offer Don't know whether or not we were able to provide the appropriate paperwork, but I hadn't heard from Mr. Garner about this case. So if we have the paperwork in order, then I'm ready to move forward.
All right.
Thank you.
Thank you. Number 2, number 3, State of Georgia versus Owen Lair. Mr. Watkins.
Yes, sir, Your Honor. I spoke with Mr. O'Melveny yesterday. Mr. Lair is unable to attend court today. He's had some pretty significant medical issues. I think once he gets healed up, that will be a plea, but we're just not quite ready to do that today.
All right. Thank you.
Rescheduling, Your Honor.
Ms. Leonard, when is our next day?
Judge, we have November 12th.
Okay. Set it down for November 12th, Mr. O'Melveny and Mr. Watkins. Right, number 4, Karen Carey. Mr. Johnson.
Anthony, we can't hear you. You're not muted, but your audio isn't coming through.
That's interesting. That would. Hey, good morning, Your Honor.
Good morning.
We reached an agreement as it pertains to Mr. Carey, Judge, but we do not have the documentation. I know that was reached with the previous district attorney.
I think there was an offer extended in this case, Your Honor, but I do note that he has another case pending before this court that I don't think has yet been indicted, and 2 that are pending before Judge Peters. Those cases involve multiple counts of aggravated assault, possession of controlled substances, armed robbery, possession of weapons, and other more serious charges. So given my that I'm new on this case, Your Honor, I'm not sure whether or not Mr. Johnson wants to just move forward on one case. And again, I don't know the status of the paperwork on it, but if he wants to try and reset it, we could certainly discuss a possible global resolution, although it would be a different ADA handling those cases in Judge Peters.
Well, Judge, here's the only issue, because this case is one of the court's older cases. And so what we had wanted to do, we wanted to clear this particular case off the court's docket because he does have cases in Judge Peters and he has an unindicted case. But this is, if I recall correctly, it's one of the court's older.
It's a 2019 case, Mr. Johnson.
I would prefer, and Mr. O'Melveny, what we can do if the court wants to, we can either pass it till tomorrow or another day. I can send you the emails between me and the previous DA so that we can kind of try and get this closed out if possible.
Sure. Like I said, I've looked in Tracker. I think we did have an offer out, and we can try and get some paperwork to you this afternoon if you want to try and do it tomorrow.
All right, that's what we'll do. We'll move it to tomorrow's docket. All right, number 5 is off, which is Laurel Brown. Number 6, State of Georgia versus Charles Norris. Ms. Dillon.
Yes, Your Honor. I don't know, Mr. O'Melveny, have you had a chance to look at this case? Ms. Flournoy and I were close on this. She had actually sent me a recommendation. Mr. Norris has 3 VOPs that didn't make it to this calendar and another new case that's not on this calendar. So I don't know if the state's had a chance to look at it.
Briefly last night, I'm aware that we have that unindicted new case. I think that he was arrested on the new case, and then warrants were served on the escape charge plus the additional VOP, which includes a case where he was allegedly had absconded before he could serve any of the sentence on that. So if you're not sure. I'd be happy to try and get this one resolved tomorrow.
Okay. I think we could resolve it tomorrow. I just may need to talk to you this afternoon. So, Your Honor, if you could just pass it to tomorrow, we'll try to get it done then.
We'll do that. It's moved to tomorrow. Number
Okay, thank you.
7, State of Georgia versus, yes, ma'am. State of Georgia versus Culp, Demetrius Culp.
Good morning, Your Honor. That's my case as well. Your Honor, with this case, I was talking to attorney Mr. O'Melveny, and I don't think Ms. Flournoy ever sent over an offer.
I did not see one.
Yeah. So,
I'm
Your Honor,
prepared to make one that I think your client would find amenable if you want to try and set it down tomorrow.
that'll be fine. No objections, Your Honor.
All right, we'll move it to tomorrow.
Thank
Number 8 is off, Lamont Brown. Number 9, Madison Biggers, Mr. Jarrett.
Your Honor, the same announcement, I think we had gotten close, but I never really received an offer. I would ask Mr. O'Melveny what he thought about it. If not, if we could resolve it tomorrow, that'd be great. If not, then the November 12th date.
I have not had a chance to take a look at this one, Your Honor, probably to give me enough time to give it fair treatment. One of the November dates would be better for me.
All right, let's move it to November 12th, Ms. Leonard.
Thank you.
Number 10, you're very welcome. Number 10, Naisha Shorter, Mr. Lakes.
Ray, you're muted.
Technical difficulties, Your Honor, but so I haven't had the opportunity to speak with Mr. O'Melveny. I have a conflict for tomorrow. It seemed like we probably could resolve this one. Could we set it for November the 12th? She's working, she's doing like solar panel work, and so I need to give her some notice when she needs to get to court.
If there's no objection by the state, it will be moved to the November 12th docket.
No, Your Honor.
Thank you, Judge.
Thank you. Thank you. Number 11, Wendy Wilkes, Mr. Deaver.
Yes, Your Honor. I don't know if she's back from the system yet. She was in prison at last time. I'm not sure if anything was brought to bring her back, and I have not spoken to Mr. O'Melveny about it.
That's correct, Your Honor. I haven't had a chance to speak to Mr. Deaver about this case or about number 12, which is the same defendant. I wasn't aware that she was in the prison system. If Mr. Deaver wants to set it for a status conference in the future, that would give us an opportunity to make sure that we're on the same page about whether we can get this resolved without a trial and what terms that would be.
All right.
Your Honor, we have an offer on the case, and I imagine she would accept it. I'll talk to Mr. O'Melveny about it. If we can just put it on the next calendar, Your Honor, and make sure she's here.
All right. Ms. Leonard, can you tell if Ms. Wilkes is in the system or she's back in our jail?
I'm sorry, Judge. There's been a warrant out for her and for a hold since March of 2020. So she's been in the prison system.
All right.
Waiting for her to get brought back here.
All right. Has someone prepared a production order for Ms. Wilkes?
I have not, Your Honor. I didn't know that she would, that we would require that.
All right. If you would prepare it, I'll sign it and we'll reschedule this for November 12th. And that would be true in her case, which is in position 12. Number 13, Shirley Lynn Etter. Mr. Guzman.
I represent Ms. Shirley Etter. She has this one case on the docket. She actually has 5 open cases. We do have an agreement on 2 of the cases. The paperwork has been signed. I just emailed it to Ms. Barker and to Mr. O'Melveny. And the remaining 3 cases will be dismissed upon the plea. So we'll be able to handle those this morning at the court's convenience. Hopefully you've gotten that message. If you haven't, please let me know and I'll resend those documents.
Do you have them, Ms. Barker?
Yes, I have them.
Okay, so we'll take care of that one today, if possible. Number 14, Anthony Pritchett Hodges is off. Number 15, Shannon Buckner. Mr. Lakes?
Yes, Your Honor. I believe we are ready to go forward on that one, are we, Mr. O'Melveny?
Well,
I've got paperwork on 13. Yeah, I got paperwork on 1352. So I could send that paperwork. I sent it, I thought, the last time we were on the docket, but I'll resend it to you and to Ms. Barker.
You don't have 1353?
No, I don't have any paperwork on 1353. Can we? Can you just get me can you get me the paperwork on 53 so we can handle that one today? Then, if we need to go forward on 1353 instead of 52.
I can try and get that to you over the break. I'm not sure. You're going to be able to get your client to have signatures on that, or?
Yeah, we can. Yeah, we can get e-sign.
All right, let's see if we can get that one done today, Your Honor. I think we've closed both 15 and 16 with one plea.
All right, thank you.
Thank you.
Number 17, James Fritsky is off. Number 18, Jason Horn. Mr. Guzman?
Your Honor, that is ready for a plea. I believe the court should have all the paperwork from Mr. Horn. It sent Mr. Horn the link for Zoom. I don't know if he's on here because there's some that aren't named. So if Mr. Horn is on, perhaps if he could say something so we know that he's here.
Jason Horn, if you're on the Zoom, please speak up. Turn on your microphone.
Yes, sir, I'm here.
And your video.
Okay.
All right.
Good. And so we're ready.
We'll do
We're
that
ready
today. Okay. All right. Number 19, Mandy Tolan.
Your Honor, Ms. Tolan, she is in the Russell County Jail still. It's a plea. As soon as we can get her back over here. So it'll be a plea.
All right, we'll move that to November 12th. Number 20, Courtney Gunn.
Your Honor, Miss Gunn, you should have the documents for her also. So that'll be a plea at the court's convenience. I also sent Miss Gunn the link. So if you could call for Miss Gunn, again, there's some, I guess, that are just unidentified here. So I don't know if she's on.
Miss Gunn, Miss Courtney Gunn, are you on the Zoom?
Yes, sir.
All right, thank you.
There she is.
Thank you. We'll come back to you in just a little bit. Number 21, Leotis Sheldon is off as there's no offer, according to Mr. Kendrick. James Fritsky in position 22 is off for the same reason, according to Mr. Kendrick. Number 23, James Fritsky is off for the same reason, as is number 24, James Fritsky. So they're off.
I made a note of the request. I'm assuming that that's a request for an offer, Your Honor. I'll reach out to Mr. Kendrick, see if we can't get something going.
All right, very well.
Your Honor, if we could revisit position 2.
All right, Ray Cokes.
That is correct, Judge. I'm going to be covering for Mr. Garner today. An offer was conveyed to Mr. Coates He has declined that offer, and Mr. Garner is aware that he is position 10 on the court's next upcoming trial docket.
All right, thank you. So he is off for today. Right. Now we go to the bond docket.
I apologize for interrupting, Your Honor, but Mr. Johnson, if you would please let me know. I want to confirm what the offer was that your client was, that was communicated to your client and that he's declined, because I'm not sure if that's the same as what I have.
I have a 10-5 with a Fourth Amendment waiver.
Okay, because I think what the most recent offer was down to 10-3 with fines, community service, Fourth Amendment waiver, and dismissal of the co-defendant's plea upon dismissal of the co-defendant's charges upon your client's plea. But we can communicate about that and see if.
Yeah, we'll talk offline about it. I'll give you a better insight.
All right. From a practical standpoint, to try to take care of some of the jail cases, I've got a listing here of the first group, none of which are guilty pleas. At the jail there, do you have Maurice Abrams downstairs and ready to come into the courtroom for a bond hearing?
Yes, Your Honor.
All right, that'll be our first case this morning.
Let me get a Maurice Abrams. Maurice Abrams.
Who's counsel for Mr. Abrams?
I am, Your Honor.
Who said that? Mr. Guzman?
Guzman.
All right, thank you, Mr. Guzman. All right. Is this your client, Mr. Guzman, at the jail?
Yes, sir.
All right. Are you ready to proceed?
Yes, sir.
Whenever you're ready.
All right. Your Honor, Mr. Abrams has two open cases at the moment. He's got SG 2021 CR 295, where he's got an obstructing 911 call with a $250 bond, and a battery family violence, which is charged as a felony with a $25,000 bond. And then he also has case number 2021 CR 274, where he has a cruelty to children, third degree. This is the misdemeanor variety of cruelty to children, 2 counts with $5,000 each bond. And then on the battery family violence felony has a $5,000 bond. He's been in custody since January 30th, 2021. And last time I checked, at least as of the filing of these motions, and I believe actually as of last week, he had not been indicted. So he's been in for approximately 8 months. And I was simply going to ask the court for a reduction to something that he might be able to make. Was a suggestion that I would have is on the cruelty to children, third degree, which is 2 counts, which are $5,000 each. I would ask the court to consider making those OR bonds. And then also on the obstructing 911 call. And then on the 2 batteries, one of them is at $5,000 and one of them is at $25,000. I would ask the court to consider making both of them 5,000, just keeping one at 5,000 and making the other one going from 25,000 to 5,000 on the other one, which would allow Mr. Abrams, of course, to possibly make his bond with reduced, significantly reduced bonds.
All right. What's the state's position, Mr. O'Melveny?
Your Honor, we oppose a reduction of Mr. Abrams's bonds because we feel that he's a risk to reoffend and a risk to the same victims that he has that he's alleged to have attacked in these cases. His history includes a 2017 battery in which he was granted pretrial diversion in state court. So that did not become a conviction. In 2018, he was also charged again with battery. These are family violence and cruelty to children. Those were resolved with a misdemeanor plea in state court, which is why we are here today on positions number 14 and 15 with charges that are battery, family violence, subsequent, third or subsequent prior forcible felony conviction. And that's why the bond in the position number 15, I believe, is $25,000, because he's just demonstrated this pattern where again and again, the same alleged victim, his son, I believe it is, who has the same name, if I'm not mistaken. So we're concerned that if the court grants him a bond reduction and he's able to obtain release, that he's going to present the same kind of threat that he has over and over again. And these are happening over in a short period of time. Just since 2017, we now have 4 instances of him being before the court with charges of having been violent towards his family member, towards his child.
All right. Any testimony, Mr. Guzman?
Your Honor, no testimony. I was just going to ask the court to consider the bond reduction, perhaps with conditions that might alleviate the state's concerns, to include no contact with the victims or the victim in the case. And he does have a place to stay in Muskogee County that he could stay, where he could remain in Muskogee County. And he also has a place where he can find employment here in the county, or at least in the area. So I'd ask the court to consider the reduction so he can make those, and considering that in particular, $10,000 of the bonds are on a couple of misdemeanors, knowing that, of course, Mr. Abrams, he is indigent. I would ask the court to take that into consideration, in particular on those misdemeanor bond amounts that seem somewhat high for what they're charged, and ask the court to just consider placing conditions to prevent Mr. Abrams from going around the victim.
All right. What is the victim's name? Is what, Mr. Guzman?
Let's see here. Ashley Abrams. Ashley Abrams. Is that right, Mr. Abrams? Ashley Abrams.
Okay. All right, Mr. O'Melveny, any testimony for the state or the victims?
To my understanding, the victims, we reached out to the victims, Your Honor. I'm not aware of them having appeared in court today. I would have to defer to my victim's advocate.
Okay. Let's hear from your advocate, your victim advocate. I want to know if the victims were notified and by what means.
Yes, Your Honor. They were notified of it. Miss Abrams was planning on being on Zoom this morning. She is having technical difficulties and has emailed me about those technical difficulties. We haven't been able to get them resolved as of yet, but she is very opposed to a bond and wanted to address the court this morning.
Well, this is the day and the time. What is her name?
Ashley Abrams.
Is Ashley Abrams on the Zoom call?
she had emailed me and told me that she was having technical difficulties and the link wasn't working for her. And that email
Okay.
came through at 9:18.
And court started at 9. We're going to move this to tomorrow. If need be, have her come into your office.
Okay.
So that Mr. Abrams can have his hearing, but we'll move it to tomorrow. Thank you.
Your Honor,
Sorry, Mr. Goodman.
it's fine, Judge. I'll definitely be here tomorrow. I wanted to mention also, it's not on this case. It's on the Brandon Barfield bond hearings. I know he's in the next group, and what I was going to suggest is I got a message from him, and I read it, and I think that there might be the possibility of a plea. And so I was going to ask the court and see if Mr. O'Melveny would like to move those particular bond hearings, there are 3 of them, to tomorrow, and that'll give us some time this afternoon to talk about it and see if we can come to an agreement on a plea. If not, we can just proceed with the bond hearing tomorrow. If that's okay.
I couldn't understand you, Mr. O'Melveny.
The state is not opposed to moving those cases to tomorrow with the hope of being able to resolve them.
All right, they're moved to tomorrow. Let's have Lavelle Stencil come out into the courtroom, please, on our bond hearing. All right, is this your client, Mr. Guzman?
He is, Your Honor.
All right, let me find him on the bond docket.
Yes, sir. Let's see. He's number 9.
Number 9. All right. Whenever you're ready, Mr. Guzman.
Yes, sir. Mr. Stansel is here before the court. He's asking for a bond reduction and also for a bond on a probation violation. Let's see, he's got an aggravated battery charged with a $180,000 bond and a possession of firearm during the commission of a crime with a $13,500 bond. And he has no bond on the probation violation warrant, SU 19 CR 2508. Now, we had a bond hearing on Mr. Stansel earlier this year. He had asked the court to set a bond on of course, on the probation violation and to reduce the bonds on these other charges. And the court did reduce the bond on the new offenses by 10%. That's why the number is $13,500 on that possession of firearm during commission of a crime, because it was $1,500 less, and then it was $20,000 less on the aggravated battery. He also has certain conditions, and I thought I had the bond order here where he has to remain within Muskogee County, Georgia, shall have no contact with the named victim, daughters, any family members of the victim, or any witness in the case, shall obtain and bear the cost of GPS-enabled ankle monitoring, which will generate a weekly report, and shall not approach within 100 feet of the victim or the victim's daughters or any witness in the above style case, and shall not violate any federal or state or municipal laws. Now, this particular case it's a serious case, Your Honor. I mean, we're treating it as a very serious case. It was the allegation is that my client, Mr. Stansel, fired a gun and hit the victim in this particular case, and so they're very opposed to a bond on this case. However, Mr. Stansel has been in jail for it's not quite a year, but almost. October 29th will be 1 year. And, you know, trying to check and see if he had been indicted. I don't think he had been indicted. I don't have that in the bond motion, but I don't believe that he has been indicted. And in either case, his VOP hasn't been heard either. So he's been in for almost a year, practically 1 year on these cases. And so I'm asking the court to consider a significant reduction on the aggravated battery from 180,000 to something more manageable and something that he may be able to make. So I was going to ask for a $40,000 bond on the aggravated battery and a significant reduction on the possession of firearm during commission. And I would ask the court to set a bond on that probation warrant because, as I said, he's not, the VOP hasn't been heard, and I'll check while Mr. O'Melveny is talking, but I don't believe he's been indicted either. And so I would ask the court to consider significant reductions in those bonds and to set a bond on that VOP.
All right. Are the victims on the Zoom call?
No, Your Honor.
Any particular reason they're not on the call?
From my understanding, they had a family event going on this week and are out of town.
All right, but they were notified in time to
Yes, sir.
be here. Is that correct? All
Yes,
right.
Your Honor.
All right, thank you.
Your Honor,
Mr. O'Mel.
Just so you know, he actually has been indicted. He was indicted in August of this year. Okay. So he is indicted.
All right, thank you. Mr. O'Melveny.
Yes, Your Honor. What I was trying to do here very briefly is to check whether or not he'd actually had a hearing scheduled on the VOP. It looks like only thing I can tell is that he had a VOP in this case back in January. Obviously, it's discouraging to see that what he was on probation for is the same type of charge, using weapons, terroristic threats, and acts, aggravated assault. And I understand that he hasn't had a chance to respond to the allegations of having violated that particular probation, but again, it's less than 2 years later, slightly more than a year that he's back on aggravated assault, possession of firearm or knife during the commission of that felony. And the allegation is that he in fact did hit one of his victims when he fired that weapon. And so we think that that if his bond's being at 180,000 and 13,500, we would ask that the court be cautious with any reduction, because we do know that the family, would be very afraid if he were to be released on bond. And we understand also that additional conditions can be placed on that. So if the court does want to, or excuse me, I'm not sure if Mr. Guzman was stating that those conditions were already placed on his bond, but if the court were to reduce the bond, we'd certainly want to see that there were appropriate steps taken, including the ankle monitor. If I'm not mistaken, there was a condition that he remained in Muskogee County, and I'm not sure whether or not that was something that the family would specifically take any issue with if he were to reside outside of the jurisdiction. As long as he's being monitored, we don't necessarily object to removing a condition so that he could find appropriate living circumstances if he were to be able to post the bond. But the amounts we think should probably remain significant based on that pattern.
All right. Anything further, Mr. Guzman?
Just ask that the court consider that Mr. Stansel, he is indigent, and what we don't want to do, is make the bond amount such that the defendant simply can't get out of jail. like I said, he is indigent. I am representing him in my capacity as an assistant public defender. The court asked the court to take that into consideration. That one of the most important considerations is, for bond, is to make sure that the defendant does appear, back in court. I know there are other considerations that the court has to take also, but that is, one of the major ones. And
Yes,
I
sir.
believe, especially with GPS monitoring, because that costs, that's an additional cost on the defendant. And so, so I'd ask the court to take all that into consideration. It's setting, if the court is going to reduce the bond and set a bond on the VOP, take all that into consideration.
All right, thank you. I believe there were conditions previously set prohibiting Mr. Stencil from going around the victims or leaving Muskogee County or interfering. The consideration that you mentioned, Mr. Guzman, is of concern to the court that a bond be set. It's reasonable, but I also have to be concerned about the likelihood of reoffending. And given that he is on probation for similar charges, that causes me to be concerned about reoffending. Also, I have to be concerned about the safety of the victim and the victims being intimidated or interfered with. What I'm going to do is set a VOP bond of $20,000 with the same conditions that exist on the current bonds, adding to it a requirement for an ankle monitor, but liberalizing the restriction on his presence, allowing him to be anywhere in the Chattahoochee circuit. And the ankle monitor will generate, it'll be a GPS equipped ankle monitor, which will generate a report to the sheriff's office once a week to show whether he is going outside the Chattahoochee circuit. I'll reduce the bonds on the other two charges by 10%. And since the case has been indicted, he's now in a position to get a trial. So thank you. If you'll prepare the order, Mr. Guzman, and allow Mr. O'Melveny to review it, I would appreciate it.
Yes, sir.
All right, let's have Chasten Hunter come out for a bond hearing, and that'll be our last hearing before we break until 11 o'clock. Is that your case also, Mr. Guzman?
That's my case, Your Honor.
If I may ask, I just have a forfeiture hearing. I know there were some set at the end. I know they always come at the end. Do you anticipate being able to get to those today? Or
is your client incarcerated, Mr. Hagler?
No, sir, Your Honor. He's not. He's online with us. The criminal case is already disposed of, but I just did not know if you needed to reset those, and I apologize for interrupting. I just wanted to go ahead. If you did, that's all I had. And we could reset it if that's what the court sees coming, and just come back at a different date rather than continue to wait, knowing we're not likely to get to us.
All right. And your client is?
Scott Couture, Your Honor. He's online with us.
Right. All the other bond forfeiture cases have been moved. Rather than keep you and your client holding, and it is unlikely that we'll get to them just because of the schedule today. Let's move it to November 12th if you're available, Mr. Hagler.
Your Honor, I believe I am. Mr. Couture, do you understand that? Mr. Couture, can you hear
Yes,
me?
sir. I understand. Yes, sir. November
the 12th.
Yes, sir.
Judge, thank you very much. And if I may be excused today, I appreciate it. Thank you.
Absolutely, Mr. Hagler. You have a good day now.
Thank you, Judge.
All right. Do we have here at the jail? Is this Mr. Hunter?
Yes, Your Honor.
All right. Counselor, whenever you're ready, please
Judge,
proceed.
Judge, we have Mr. Justin Hunter here. He has been in jail for 81 days. The next non-jury day would take him past 90 days unindicted. He's got 6 counts. Yeah. I don't have any discovery on this case. I don't know the specifics of what's being alleged in the damage to property charges. The merits of the accusations aren't really a consideration in bond. The only thing I would get into in the case is there's an obstruction and an escape without any discovery. I don't know what those are based on separately. I think they may actually be based on the same action. But he currently does not have bond on either of the criminal damage second charges, the escape charge, or the obstruction charge, as far as I can tell. There are bonds set on the criminal trespass and the battery charge. As I stated, he's been in 81 days. He's not technically entitled to a bond right now. However, our next non-jury day would be after his 90 days by about the same amount that we're short right now. I just asked the court to consider setting reasonable bonds on this case. It doesn't appear that there are, again, I'm not sure what the criminal damage allegations are. Obviously, any condition of not contacting the victims in those cases, the escape and the obstruction would obviously pertain to officers. I don't think there's any danger of him intimidating witnesses in those 2 cases. Mr. Hunter is represented by our office. He's not going to be able to afford a large bond. I'd ask if the court possibly consider granting something like UJR bonds on all the misdemeanors, and then setting reasonable bonds on the felony charges in front of the court today.
All right. Mr. O'Melveny.
Your Honor, given that he's already got bonds on the battery, that would be, the one where we would be most concerned about there being potential for harm to a victim, and we assume that there will be a stay away condition if he were to make bond on that. I don't object to a reasonable bond being set. I've not had an opportunity to discuss specifically with the victims in this case as to what the damages were, what those amounts were. So it's difficult for me to provide the court with a clear picture of what a reasonable bond for these would be. But it's also important, I think, for the court to take note that these are not the only charges that Mr. Hunter is currently facing. It would appear that he has SU 21 CR 241, alleging burglary, possession of tools for the commission of a crime. 2 counts of burglary in the 1st degree, aggravated assault, and 2 counts of cruelty to children in the 3rd degree. SU 21 CR 194, unlawful to knowingly remove, destroy, circumvent, or circumvent the operation of electronic monitoring device, which, based on the charge, not really knowing the specifics of that case, either suggests to me that he's trying to take off an ankle monitor. Certainly that's worrying consideration if he's unwilling to comply with some of the most strict opportunities or options we have for supervising people who are out on bond. He's also has an open case SU 20 CR 2705, in which he's charged with criminal damage to property, 2nd degree, willful obstruction of law enforcement officers, and disorderly conduct. So again, what we see is a pattern where he does not want to cooperate with law enforcement officers. He does not want to be confined, restricted, or supervised in any way. And he has a pattern of damaging other people's property, of threatening other members of our community, included through aggravated assault, cruelty to children, and disrupting the community through disorderly conduct. He's a threat to property because he's got multiple burglary and damage counts. And we know that there are potentially pre-filed charges alleging aggravated assault and additional burglary in the 1st degree. I don't know what the status of those is or whether they'll be.
All right. I hate to interrupt you, Mr. O'Melveny. I'm going to have to take a break now. We'll resume at 11 o'clock. Ms. Barker will give everyone instructions as far as staying on the Zoom platform. And we'll resume in about an hour and 10 minutes. Thank you.
I'm just going to leave this running so everybody can just stay logged in and you don't have to worry about it. It'll be right here when you come back.
Mr.
Thank you.
Goodman,
And if you decide to dump out, I'll let you back in also when I see you're in the admin in the waiting room.
Mr. Goodman. Mr. Goodman?
Thanks.
Yes.
Yes, sir. We have Miss Etter here in the courtroom at Recorder's Court.
Okay. Okay.
Now you want to stay here till for the 11 o'clock, right? You want to be back for the 11 o'clock.
Yeah. I'll call her on her cell phone, and I'll talk to her about like just getting the Zoom link if she'd rather do that. But I'll talk to her on the phone.
Well, I mean, she's right here. I can have her walk over to you. But
Oh, okay. Okay.
you want her to talk to you right now?
Sure.
Okay, come on, hang on. Miss Etter, come forward, please. Get Mr. Goodman right there, okay?
Okay. Ms. Etter, do you want to return to the Recorder's Court at 11, or do you want me to send you the Zoom link?
Just give me the Zoom link since it's being continued.
Okay. Okay. I'll send it to your email. Just make sure and be on, right at 11. Okay. Or, a little earlier if you can. Okay.
Okay, thank you.
All right. Thanks.
It's fine.
Thank you, Mr. Goodman.
All right. Thank you.
I've got the, Mr. Guzman, I've got those two, dismissal in those two that weren't, I think, accused on Ms. Etter. I think we're just going to do a warrant dismissal. The other case I hadn't actually looked at, so once I'm able to confirm everything, I'll probably get that one in later. That was the one that I think you'd already talked to Ms. Flournoy about, something about charges over in Alabama, and they weren't able to really connect the dots in how things in Alabama were being shown to have connected to her in events in Columbus or what have you.
Yeah. Okay. Okay. Do you want to give me a call and we can talk about those other bond hearings?
Well, I can try. We're not gonna come back on until 11 here, right?
Mm-hmm. Right.
I think I've got to try and get some paperwork drawn up for Mr. Cokes.
I was just going to see about that one, Mr. Matthews, Carlos Matthews, because he's the one that I wanted to see about just changing the conditions so that he can go to Russell County.
Oh, okay. I may have thought you were talking about that with standstill. Okay. Yeah, if you want to give me a buzz, I'm at 3669.
Mr. O'Melveny, this is Mr. Shelnut. Could I give you a call also? What's that number?
It's 366. Well, outside it's 706-225-3669.
Okay, I just was hoping we could talk briefly about our case on there. Number.
Yeah, give me a minute here, and
sure.
When I'm done with Mr. Guzman.
Thank you. Okay.
Hello. Mr. Johnson, are you there? Mr. Johnson? Hey, Ray, it's Robert. So on there a DCS representative online right now? Is there anybody online?
Yes. I'm with DCS. How are you?
Hey, this is Assistant District Attorney Robert O'Melveny, and I'm looking at the remaining cases. Of the first 5, we've got number 6 on the VOP docket, Daryl Cochran, and number 5, Khalil Jones. Are those, let's see here.
Mr. Cochran is assigned to me.
Okay, who am I speaking with?
This is Officer Reed, Sonia Bryant Reed.
Hey, how's it going? So you've got.
I
You
just
say,
got off the phone with the clerk of one of the clerks in Louisiana regarding condition number 1 for Mr. Cochran.
this is what I was gonna tell you is that, okay, hang on, let me catch up. I just got a copy of the petition, so, so what did they say about Louisiana?
He's disposed of the case there. He
Okay.
only entered a guilty plea to illegal use of weapons, dangerous instrumentalities. That's the only charge that he entered a guilty plea to and was sentenced to 18 months hard labor. So the other charges we can strike through those.
Okay, what do you, when you say strike those?
Oh, I
mean
mean,
that
those are
ones
not,
we would
they did
change
not
in your
move
place
forward
of
on those,
Okay.
the other 2 charges.
Not change place of abode or move outside. So he wasn't supposed to go to Louisiana in the first place.
No, what happened was he initially was sentenced under this particular docket to serve 12 months in custody. As soon as he was released, he went to the sheriff's office and advised them of an address in Louisiana, but never informed the probation office of his change of address there, because what should have taken place, there should have been a transfer submitted, an interstate transfer, but that never took place. And so the assigned officer at the time was not aware that he was out of the state. And so when she learned of it, a warrant was issued. So that's why he was charged with the violation of changing his address without permission.
The fact that the charges in Louisiana were reduced or resolved, does that change your position on your recommendation of 5, minimum 5?
No. She's going to be mailing out a certified copy of the disposition.
Yeah, because I don't have anybody here that can testify to. When you say she's going to be mailing out, are you talking about
The clerk of court will be mailing out today a certified copy of the disposition from Louisiana regarding that case.
Okay, so the Louisiana clerk is going to mail something to us, but they're just now getting it mailed, so that means we don't have, we can't.
I'm sorry, I can hardly hear you.
I can't proceed on that until I have that paperwork, unless I were to have a witness that could attest to it, which would leave us with technical violations and 2.
I would just rather wait until we can handle everything at once.
You know whose attorney is?
No, I do not.
I don't know. I don't think he's got any new charges in Columbus, does he?
I'm sorry, say that again.
Does he? He doesn't have any new charges in Columbus, right?
No.
Do you think that, well, I guess we would have to wait and see as far as when we could get the paperwork on that.
Yes.
When do you think you want to set this thing down for the next date if we're going to ask for
Yeah, if
continuance?
we could ask for the next available date, I anticipate the clerk is gonna, she said she would mail it out today.
Okay.
So
November 12th, it looks like.
November 12th is the next available.
I think so.
Okay, we definitely should have it by then.
Are you also handling any other cases?
That
Will Jones
is
would have been the
my
next. He's number 5 on the BOP docket.
Hey, this is Officer Davis for Khalil Jones. I think I heard you say something about him.
Yeah, he should be next as far as whether if they're going to continue to follow the 5 defendants at a time. It was a bond motion and then Daryl Cochran, another bond motion, a bond
So is
motion that the
Jones-
court hasn't ruled on, and then we'd come to Khalil Jones.
All right, Jones is down for VOP, correct?
Uh-huh.
Okay.
Revoke in full until
All
2030.
right. We'll continue with the bond hearing for Shaston Hunter.
Hey, let me get Chaston Hunter. Chaston Hunter.
Judge, while they're getting him, could we make an announcement? If
All
possible.
right. Yes, sir.
We had numbers 1, 2, and 3 on the probation motion. I mean, on the motions list, there were 3 separate petitions, I think, or probation warrants that we had filed for.
Are we talking motions or for VOPs?
I'm sorry, it's on the motions for a VOP bond. I apologize. Numbers 1, 2, and 3. Reginald Lewis. I talked with Mr. O'Melveny, and there were some things we needed to look into about it. I was going to ask the court if we could roll it over till tomorrow, because we may be able to work something out if we can check on a couple of things with it. But if not, we could have it tomorrow if that would work with the court.
If the state is agreeable, that's fine with the court, Mr. Shelnut.
We are, Your Honor. We've got some question about the defendant came over from Russell County, Your Honor, and we want to get in contact with Russell County to determine the status of that case before we proceed with this motion.
All right. All right. Well, thank you.
Thank you, Your Honor.
Thank you. You're very welcome.
Your Honor, is that Reginald Lewis? Your Honor, Deputy Valley speaking. Is that Reginald Lewis?
Who is speaking?
That's the jail, Your Honor. They were asking if we were talking about Reginald Lewis, and we are, Deputy. He's in the next group.
Thank you.
All right. Mr. Biddy, you were still in your presentation, I believe, and we had to stop.
Well, I had completed. I had completed, so Mr. Biddy can proceed if he wants to present any witnesses or if he has argument.
Judge, Mr. O'Melveny brought up the open cases that Mr. Hunter has. I'm aware there are several pending cases against him. However, there's not a single one that's indicted. He stands arrested of these charges at this point. And I don't understand the delay in indicting those cases, but I don't believe that an unindicted case even an indicted case can't be held against him in terms of his presumption of innocence, but certainly an unindicted case on which a grand jury hasn't even heard the merits, I don't believe should be held against him for bond. And what I was, just to reiterate, simply asking for is that the misdemeanor charges be granted UJR bonds and very reasonable bonds be set on the felony charges. I believe any bond that he's unable to make is going to end up with him sitting in our jail for quite some time, as we have year-old cases that are unindicted. And once it gets indicted, it's going to the back of the trial docket. So that's just our request to the court. And just to reiterate, it's my belief that it would be proper for the court to give him a bond. The next court date is after his 90 days. We're within 9 days of his 90-day entitlement to bond.
All right, Mr. O'Melveny, what was the amount involved in the 2 criminal damage to property cases? Do you know? Were you able to determine that during the break?
I was attending to a couple of other matters, but if the court will indulge me for one moment, I will do what I can to try and pull that information up.
Mr. Biddy, you may know this. He doesn't have bond on either of the criminal damage to property charges. Is that correct?
And that the escape charge, and it appears in Odyssey that even though that obstruction is a misdemeanor charge, there was no bond set on it. Of course, all defendants are entitled to a bond on a misdemeanor charge from their first appearance. How that got through, I'm not sure. But yes, Your Honor, you're correct.
Thank you.
And it's been a minute since we were in here, but it's my belief, based on my slight understanding from the little paperwork that I have, that the escape charge and the obstruction charge probably stem from the exact same thing. So I would, obviously I'll take it if it's on the escape, but I would certainly request that one of those be a UJR bond.
This one does not, 1556, does this entail a burglary charge, or will this not a burglary?
It does not. It's one misdemeanor obstruction, one misdemeanor criminal trespass, 2 property damage seconds, a battery, and an escape.
I want to see if I can pull this off of the warrant, because I don't think I have the right reports attached here, but it looks like we have approximately $1,800 current estimate based on damage to some windows. We think there's some damage also to a vehicle. Unfortunately, I don't have anything more specific than that at the moment, Your Honor.
All right.
We don't oppose a reasonable bond. We're not saying that because the man's 9 days from his 90-day point, the court should not set any bond, but we want the court to take into consideration that it's not just a matter of, having proven whether he committed those things. It's a matter of him having been out on bond on those cases and then getting new charges and getting new charges and getting new charges. And so the concern is the specific bond factor of, is he going to be a threat to persons or property in the community? Is he at risk of reoffending? certainly there's a high risk where an individual shows repeated arrests in this window of time. And I don't necessarily agree with Mr. Biddy's assessment that Mr. Hunter has had to wait an inordinate amount of time without being granted a reasonable bond, since he has not been in jail for a full 90 days since his previous arrest. The lack of indictment at this point, I think the court is well aware, is due to a number of factors, some of which are entirely outside of the control of the district attorney's office. Certainly, we're going to do our best to try and move these cases as efficiently as possible. But the fact remains that Mr. Hunter, regardless of how quickly we move to indict him, is a relatively high risk of committing new offenses.
All right. Well, that is a factor I take into account. I have granted bonds for defendants who've been in jail for 4 or 5 days. I don't stand on waiting 90 days in all cases, because I always observe if it were one of us who was incarcerated, 1 day would be a very lengthy time. Is this simple battery or battery, Mr. O'Melvini?
Section 523.1. It's listed as battery, Your Honor, which I believe is simple battery, unless it specifies otherwise that would be battery with physical harm.
Okay. All right. Is the victim, I may have asked this an hour ago, but is the victim aware of this hearing today?
Okay. Yes, Your Honor. We reached out to the victim. Don't believe that she was available to appear today, and it is charged as battery, not simple battery, but battery, Your Honor.
All right. All right. Here are the bonds on
Judge,
the
I believe the victim advocate is on the line and may have had something to chime in on the victim's rights.
All right, Ms. Forey.
Yes, Your Honor. I did speak with the victims. The nurse at the hospital was one of the victims for the battery charge. She stated that she's leaving it up to the court's discretion, as she has understanding that the defendant may or may not have some mental health concerns. So she's just leaving it up to the court.
All right. Anything further from the lawyers?
Nothing further, Your Honor.
All right.
On each of the court does grant a bond that it consider a condition that the defendant obtain a mental health evaluation. He was ordered, I believe, to see the county physician, but I don't know whether or not that had actually occurred.
Well, I would take that up in a separate motion if you're asking for a psychological evaluation. On the criminal damage to property in the second degree, a $1,000 bond on each. Willful obstruction of a law enforcement officer, a misdemeanor, $1,000 bond. The escape charge, $25,000 bond. Criminal trespass, $1,000 bond. Battery, $10,000 bond, and the other bonds previously set will remain as set. The defendant will wear a GPS-equipped ankle monitor at his expense, which will generate a weekly report to the sheriff of Muskogee County, Georgia. He shall be restricted to the Chattahoochee Judicial Circuit. He'll stay away from his victims, plural, in this case. Mr. Biddy, if you'll prepare the bond, let Mr. O'Melveny review it. I'll sign it as soon as I have it. Thank you.
Thank you, Your Honor. Just one question on that. The terms you just issued are slightly conflicting. The battery had a previously set bond of 2,500, and you just announced it.
No,
Okay.
I did not know he had a bond. It'll remain at 2,500.
Okay, at the previously set amount. Thank you, Your Honor.
Previously set amount. Thank you for that question, Counselor. All right, let's go to Daryl Cochran on a VOP hearing. He's in the first group.
Daryl Cochran.
I'm not sure who represents Mr. Cochran.
I generally have notes on my docket of who represents them. Oh, I'm Mr. Cochran.
After a conversation with the probation officer, Your Honor, came to light that there is evidence that we're still awaiting from the jurisdiction in Louisiana where he was charged with new law violations, and we're in the process of obtaining certified convictions on those. So we were going to ask that the court reset this one for the November 12th date.
Okay. Does Mr. Cochran have counsel?
I'm his attorney, Your Honor.
Oh, Mr. Biddy. All right. Do you object to a continuance?
Judge, I just want to be clear. There's an allegation of new law violations and apparently a certified conviction coming. There's multiple things alleged in the delinquency report, but what was Mr. Cochran actually charged with or convicted of in Louisiana?
Well, I haven't seen that documentation yet, Your Honor. So that's why we want to go ahead and get the certified conviction before we proceed against him. We're just asking that it be rescheduled so that we are not providing misinformation or inaccurate or incomplete information before the court has to make its decision.
Judge, I would ask that the court consider granting Mr. Cochran a VOP bond. He sat down to be before Your Honor today and then sits in jail, gets brought before the court, and the state says, well, we'd like to leave him in jail a little bit longer. We're not ready to proceed with what we've asked for. I believe he was brought from Louisiana to our jurisdiction and is being housed in our jail at our expense now. I'd like to be expeditious about this.
The reason that Mr. Cochran is sitting in our jail, Your Honor, is because rather than reporting to his probation officer in Columbus, he absconded to Louisiana without obtaining permission from Department of Community Supervision in Georgia. So I don't think he can reasonably argue
Right.
that.
Well, I understand that's the allegation. How long has he been incarcerated, if either of you know?
It looks like July 27th, according to the delinquent report. Nearly 3 months now.
Well, that may be when the warrant was sought. When was he actually taken into custody?
Now, the delinquent report notes arrested on VOP warrant, Muskogee County Jail, July 27, 2021.
That's correct. Because after he handled the case in Louisiana, for which we're awaiting the documentation, Your Honor, he was transported back here, I believe, on hold. So.
All right. Well, I don't like pushing it out almost another month, but it looks like that's going to be necessary. So it'll be moved to November the 12th. And have your documentation ready, Mr. O'Melveny. Thank you. We'll go to Kaylee Jones.
Judge, would the court consider granting Mr. Cochran a VOP bond based on the length of his incarceration and that we're pushing this out now another month?
Not unless the state agrees to it, because the state's entitled to notice of a bond hearing.
No,
Well-
we don't agree to it. And my point wasn't, to say that he's guilty of what he's charged with. My point was to say that, the risk of fleeing is obviously an issue here, where the allegation is that he fled probation supervision. So we do oppose
Right.
granting a bond.
Right. And that would be a factor I would take into account, but is the state willing to waive the filing of a motion and notice? Or do you have enough information to respond?
If we're going to, we'll waive we would waive notice, Your Honor, and I would have the probation officer sworn in and testify as to the issue of the defendant's conduct under supervision, because it relates to his risk of fleeing.
All right. Bond hearing only on the VOP. Okay, so that would be your motion, Mr. Biddy.
Well, Judge, if that's how we're going to handle this, I would just first make a motion for a dismissal with prejudice of this petition to revoke probation. The state set this. The state brought him here. The state's not ready to go. The state has nothing to present to the court that they cannot do without violating hearsay rules. This petition should be dismissed with prejudice because I didn't bring him to this court. I didn't set this court date. I'm not the one who's unprepared for it and unable to offer the court what they need to make a ruling. That's what I would ask for first. And if that's denied, then we can try and have a bond hearing.
Okay, that motion is. Go ahead, Mr. Mulvaney.
I'm just a little confused if what Mr. Biddy is trying to argue is that, we just want to make clear that the reason we would swear in a witness would be for the bond motion that he is proposing. The court has already ruled that it would grant the continuance. There's no point in a bond hearing if there is no continuance.
There is a continuance on the bond hearing on these new law violations. Well, actually, I've ruled on that. I've given you a ruling on. Wait a minute, no. Are we still on Hunter?
We are on Cochran, Your Honor. Just the question. Okay. The question is whether Mr. Cochran is entitled to a bond on his VOP, and the defendant has requested, in addition to that, dismissal after the court had already granted the state a continuance to obtain further documentation in support of its VOP motion. I think the question before the court properly is not one of whether the motion can be dismissed because the court has granted the continuance. The question is whether or not he's entitled to a bond. And if there's argument to that, we have a witness to respond to that.
That's the posture I find it to be, and I've already granted the continuance. You then ask if he could have a bond hearing seeking a VOP bond, and Mr. Melvin has waived a motion and notice. A written motion. So that's where we are now. If you want to go forward with that, otherwise we've got limited time and I need to move on. But if you want to proceed with a bond request for a bond on a VOP.
Understood, Your Honor. And I know that's fine. I know what the state is going to argue. I know what's alleged in the petition. It's just that Mr. Cochran has been here going on 3 months now. It will be well over 3 months by November the 12th. Just asked that he be granted some sort of VOP bond. He's sitting in our jail with, I don't have the right to discovery on a VOP hearing. I don't have anything to go on presented by witnesses who have firsthand knowledge of it. So I just asked that the court consider granting him some sort of reasonable bond so he's not sitting in our jail for another month, waiting to find out if we're ready to go on the 12th.
All right. I don't think justice is going to be served by rushing this today. Ms. Barker, do we have a 2-hour block sometime in the next 2 weeks when we could just hear Mr. Cochran's case?
Not
Ms.
in the
Barker?
next, yes, sir, not in the next 2 weeks, but possibly Friday, November 5th.
Well, that's a little over 2 weeks. That's more like 3 weeks, but it's still a week earlier than the 12th. I'm going to move this to Friday, November the 5th. Everyone be ready to go.
Thank you, Your Honor.
What time, Ms. Barker?
I would say 2 o'clock.
Okay, 2 p.m., November 5th. All right, now let's go to Kaylee Jones.
Judge Smith,
Yes, sir.
sorry to interrupt while they're getting Miss Jones. I have an announcement. I have an announcement on.
Go ahead, Mr. Lake.
I have an announcement on number 15 and 16. Shannon Buckner that appears on the guilty plea docket, Judge. I believe Mr. O'Melvin.
Hold on.
Yes,
Let me get there.
yes, sir. Sorry.
Shannon Buckner, 15 and 16.
Yes, I believe
What's your announcement?
Yeah, I believe Mr. O'Melvin and I are asking that it be set down for November the 12th. So that we could get the paperwork and everything arranged. And he's out on bond. He's out on bond, Judge, and it's going to be a plea, have an agreement that we have agreed to.
That's correct, Your Honor. We just need to
All
make
right.
sure we get the correct paperwork. Apparently, there was some miscommunication in what was forwarded to the defendant, but we'll get that corrected and it should be ready to go forward on the 12th.
All right.
Thank you, Judge.
Both of they're moved to the 12th. You're welcome. All right. All right. Do we have Defendant Jones in the courtroom?
Yes. Jones in the courtroom.
Is Mr. Jones represented?
Mr. Jones, do you have a lawyer?
Yes, sir.
Who is your attorney?
William Kendrick.
Okay.
Oh,
Mr.
yes.
Shulnut,
I
are you
see
handling
that.
that?
I see that that's on the calendar. Mr. Kendrick, I think, had filed. I was trying to help make announcements for him on that. So I'm not, prepared to have a hearing on it. I usually on these, we request an in-person violation of probation hearing. Does the court have any of those dates available by chance for an in-person hearing?
Ms. Barker?
We're in person tomorrow, Judge, and let me check. And then again on November 12th.
Okay.
Okay.
I'll give you your choice, Mr. Shulnut.
Could we roll it over to tomorrow, Your Honor? And
We will.
Then if that's acceptable with the court and Mr. O'Melveny.
All right. Is that all right? Is that okay with you, Mr. O'Melveny?
Fine, Your Honor.
Okay. Let's move to tomorrow.
Thank you.
All right. Now, you're welcome, Mr. Shulnut. Let's now go to the second group.
I think that was all I have, Your Honor, if I could be excused.
Yes, sir. Have a good day.
Thank you too. Thank you.
Thank you.
Your Honor, I know we're short on time. If I may just inquire, I have a properly filed motion for Erin Burgess. Everyone has noticed. We're ready to go forward on the hearing. Can I find out what group she's in to make sure we're going to be able to reach her today?
She is in the second group, but we have only 20 minutes left of time this morning.
We bring her out.
I can move her to tomorrow, Miss Curry, if that would help you out.
I'd rather, if I can get her done today, Judge, I'd rather get her done today.
Well, these are taking 10 or 15 minutes apiece. I'll
It's
do good to
been-
get one done.
I agree with you, Judge. It's been a little ridiculous today, I'll be honest. It's not your court, not your honor's fault. I appreciate the court's patience with everybody, but it's been a ridiculous morning. So hopefully we can get to her. I'd appreciate it.
If we can, we will, Miss Curry. You know we will if we can.
I know, Judge.
If
Thank you.
not, do you want, as a backup, if we can't get to it, do you want it tomorrow? Or do you have a conflict?
No, sir. I mean, if I absolutely have to be there tomorrow in person, I will be.
Okay, well, I'm going to be here.
I know,
So,
Judge.
We'll try. Okay, thank you. Let's go on then with, do we have Charles Norris in the courtroom? Charles Norris.
Son, I thought they
That's
were
the second
all-
group.
Charles Morris.
Charles, I'm sorry, Charles Norris is for tomorrow.
Yeah, he's
Is
off.
Clayton Park? How about Clayton Parker?
I think he's off also, Your Honor.
But he might be down here.
I haven't been told that.
Your Honor, on Mr. Parker, that was a bond hearing.
Yes, sir.
And I'd spoken to Mr. O'Melveny. That'll be a consent order, so we can take him.
All right. All right, then we don't need him. We need Erin Burgess.
Aaron Burgess.
Your Honor.
Yes, sir.
Hey, I have a Uriel Reed. Is he in the third group? And I wouldn't
He's in
object. Okay.
He's in the third group.
And you said
Mr.
is everything going to end at 12? I wouldn't object to hearing it tomorrow if that would please the court.
All right. Thank you. We'll move Mr. Uriel Reed to Friday. Thank you, Mr.
Thank
Chair.
you. Thank you, Your Honor.
Yes. All right. Ms. Curry, let me find your client on my docket so I know what she is charged with.
He's
Thank
number
you, Judge.
18 on the motions docket, Your Honor.
I got this.
Thank you. That's very helpful. I see her. Yes. Okay. All right, Ms. Curry, this is your client's motion for a VOP bond, correct?
That is correct, Your Honor. Ms. Burgess has been in jail since June 20th of this year. She does have bonds set on her Chattahoochee County case in the amount of $5,000. Judge Rumor set that bond on August 12th. I have yet to be served with a petition on the VOP. I was appointed to represent her in Chattahoochee County. She is indigent. And so I'm asking for a VOP bond. Her new charges are drug related, just as her VOP is. So I'm just asking for, quite frankly, an OR bond on the VOP, as I still haven't been served with a petition and she's been in since June.
All right. What is the nature of the drug charge? Is it a user type charge or a dealer charge?
User, Your Honor.
User.
Yes, marijuana less than an ounce and different Schedule 2 and Schedule 4 and drug-related objects and drugs not in original container. So it's all just user amounts. That's why it's such a low bond in Chattahoochee County. It's just $5,000 on those charges.
But then she was brought back to Muskogee on a Muskogee probation case, correct?
That and we house our Chattahoochee inmates in Muskogee County too. But yes, Your Honor, she is on a Muskogee VOP.
All right. Thank you.
And that was one count of violation of Georgia Controlled Substance Act. Again, one count of a user amount.
All right, Mr. O'Melveny.
I'm briefly looking at the petitions here, which Ms. Curry states that she had not served, but I had not actually had an opportunity to look at either. And she's charged, Ms. Burgess, with possession of drug-related objects, drugs not in the original container, possession of marijuana, possession of Schedule II controlled substance, possession of Schedule IV controlled substance in Chattahoochee County, and failing to report as required.
I literally just got all that. Yes.
We're going to forward you, I'm going to email you a copy of these, Ms. Curry. On the second case, they're the same allegations. It's just that she was on probation for 2 cases, the 21757, possession of methamphetamine and possession of drug-related object. And the previous case that I just mentioned is SU 21 CR 478, also possession of methamphetamine, possession of hydrocodone, and possession of Schedule IV controlled substance. It's my understanding that she was in consideration for adult drug court, which would, I believe, entail, if she were accepted to the program and voluntarily participated, would entail an own recognizance bond, but it would be under the supervision of treatment providers and probation. And so if the court wants to go ahead and grant her a probation bond, we would just ask that there be a condition that she, to ensure that she doesn't end up coming back on another VOP or another drug charge. I'm not sure what might be appropriate to try and ensure that that happens. Is she already subject to a testing requirement or treatment requirement to her existing probation?
I'm sorry, I thought this would be pretty straightforward. Yes, I have filed an application for adult drug court. I haven't gotten a response on that application yet. But that would of course be for the new Chattahoochee case. I'm just asking if the state objects to a VOP bond today.
Okay. So it sounds, I don't have a petition. I don't have any paperwork on the VOP, on the probation matter. But if someone would just tell me succinctly, are there 2 misdemeanors and 2 felonies that we're dealing with on the VOP?
On the VOP, Judge, she had 1 felony, 1 misdemeanor that she is on probation for. Yes, then we don't have a petition that's been filed on that yet. That's why I'm asking for the bond on it.
All right. Do you want to be heard further, Mr. O'Melveny?
No, Your Honor.
Okay, I'm going to set on the VOP a $5,000 bond. It'll be unsecured judicial release.
Thank you, Judge. I'll prepare the order.
Which is what we used to call OR, and everyone understood what OR meant.
Yes,
All
sir.
Thank you.
Thank you, Judge. May I be excused?
Yes, ma'am. You have a good day.
You too.
Is Jimmy Bryant available to come out?
Jimmy Bryant.
Good morning, Your Honor. This is Anthony Johnson. I have position number 12, Kelvin Trailer, Judge. I'm going to ask if he could be just continued until tomorrow for a bond hearing.
Let me find him, Mr. Johnson. He's not in jail, is he?
Well, he's actually in DOC custody, Judge, but he has given me written permission to excuse, to have his presence waived if the court's amenable to that.
If the state doesn't object, I'll accept that. If you filed it with the court, if you'll file it with the clerk, we'll move Kelvin Trailer to tomorrow, Mr. Johnson.
Okay. Thank you, Your Honor.
Well, you're welcome. All right, is this defendant Jimmy Bryant?
Yes, sir. Yes, sir. Yes, sir.
Trying to find Mr. Bryant on my docket.
He's number 19 on for a bond hearing, Your Honor.
I see him, top of the page. All right. Mr. Biddy, this is your client's motion for a bond, or is it for a bond reduction?
It's for a bond reduction, Your Honor.
Okay, thank you. Whenever you're ready.
Judge, Mr. Bryant resides in Columbus, Georgia. I'm not even sure he knows Mr. Lewis, who is the alleged victim in this case, but I can guarantee you from our conversations, there's no risk of witness intimidation, anything like that going on in this case. He's been sitting in the Muskogee County Jail for 147 days now. His case is still unindicted. He currently has bonds of $50,000 on the aggravated assault charge and $1,000 on the remaining charges. He's unable to make anything in that realm. He's represented by our office. He couldn't afford an ankle monitor if that was a condition of it. He does have a place to stay in town if he were to be released. What we're asking for is a reduction of these bonds by 90% down to $5,000 on the aggravated assault and $100 on the remaining charges. This case has been sitting for nearly half a year unindicted at this point. And to the best of my knowledge, he doesn't have any failure to appears on his record. I don't believe he's any danger of fleeing the jurisdiction, not showing up for his cases, committing additional felonies, anything like that. And that's what we're requesting. That was in my conversations with Mr. Bryant. What we're requesting is basically the absolute most he'd be able to afford to get out. And it's questionable even at those amounts if he'd be able to afford bond. We may be coming back before this court asking for a further reduction.
Mr. O'Melveny.
Your Honor, our victim has raised concerns at the last hearing. It's my understanding that the victim was strongly opposed to bond or bond reductions. Certainly 150 some days, while it might be frustrating for Mr. Bryant, is not terribly unusual period of time to investigate alleged aggravated assault involving a gun. It's the kind of case that we want to get right, Your Honor. And so we would ask that the court proceed with caution in making a determination of what the appropriate bond amount should be.
Is Ms. Flory on the Zoom?
She is, Your Honor.
Is the alleged victim on the Zoom?
He is not. I did send him the link for this hearing, and he was notified of it. I don't know why he's not on the Zoom today, but he was in court last time to give his impact.
All right. Is this a neighbor? Is this a neighbor against neighbor situation?
If no one else wants to chime in, from what I can tell on the recorder's court transcript that I've been through, Mr. Lewis was looking for properties to buy and flip. So I don't believe he lives in that area. I don't believe they're in close proximity to each other ever.
Okay. All right. Was the victim shot, or was the victim, the alleged victim, someone who had a gun pointed at him?
This is something the state could speak more accurately to, but from my understanding, it was pointing, not actual being shot.
The allegation is that Mr. Bryant was pointing a revolver at the victim, Mr. Lewis's head, and went so far even as to pull the trigger while it was still pointed at his head. The gun did not discharge.
All right. Any testimony, Mr. Biddy?
No, Your Honor.
I believe there's also evidence that Mr. Bryant may have fired the weapon as Mr. Lewis was leaving the area. He's testified, or he reported to police that he heard 2 or 3 gunshots coming from that area as he was backing up his vehicle, and obviously he was in considerable fear for his life.
All right. Mr. Biddy, do you wish to open and close or waive opening and close?
Judge, I'll just close and briefly respond to what's said. As I mentioned, this is an unindicted case. I can't speak to any of the specifics. I can't tell you why someone may have heard gunshots. I can't tell you if a gun went off or not. I can't tell you if a gun was recovered. I don't have any discovery on this case. What I have is a client who's been in jail half a year on an unindicted case. And you know, the state wants to say it's not an unreasonable amount of time to get a case taken care of, but it's an unreasonable amount of time to hold someone without a formal accusation. And, you know, he carries his presumption of innocence throughout this trial. And I have nothing. I've got a client who's been sitting in jail 6 months.
Okay. I understand that. And in Georgia, 45 days in jail without being indicted is considered a late indictment, as you both know. But I also know that Mr. O'Melveny has just inherited a tremendous caseload, but that doesn't help Mr. Bryant. Closing, Mr. O'Melveny?
No, Your Honor. We understand that the victim is concerned for his safety because he doesn't know why this was done. Certainly, we would hope that the court respect the fact that we can't be assured that Mr. Bryant wouldn't take his frustrations out to a further extent, but we leave the setting of bond to the discretion of the court.
All right. Well, Mr. Bryant is cloaked with the presumption of innocence. This would be considered a late indictment case. I do recall the victim's testimony at the previous hearing. I rather imagine I set some conditions for the bond when it was imposed. What I would typically have said is stay away from the victim, have no contact with the victim, remain within Muskogee County, Georgia, a sunset to sunrise curfew, not approach within 1,000 yards of the alleged victim, Mr. Lewis. I'm going to reduce the aggravated assault charge, but not by a large amount, but just in recognition of the length of time that Mr. Bryant has been confined. I'm going to reduce it from $50,000 to $35,000. The other bonds will remain as set. And Mr. Biddy, if you would prepare that new bond order, I'll sign it today or tomorrow.
Thank you, Your Honor.
All right. Well, we're at the end of the time that we have available. Another judge has scheduled the courtroom for this afternoon. And this will conclude our docket today. We've gotten through the first 2 groups. We'll have another list of defendants for tomorrow for arraignments, guilty pleas, revocation, and anything else that's on the docket. Tomorrow we'll be at the Recorder's courtroom attached to the Muskogee County Jail. We're adjourned for the day. Thank you.
Thank you, Your Honor.